Um, as you can imagine, we come up with creative names. And it allows the trustee, that's when there's certain provisions that you should have in there. Why? Because if you have multiple properties, you may or may not want, if you have a spouse or loved one, who do you know that's going to handle those LLCs? So we in turn take the clients that have certain LLCs and real estate investments. Who do you want to handle these? Oh, so-and-so is from out of, so-and-so understands the business, I want them in here. And there's some critical steps that you should probably have in there to allow the trustee access, if it's transferred in there. Because if not, if there's a question of what to do, the family has to file with the court. So it's always more inclusive as to what your intentions are to have it in writing. So yes, have that transferred. Now real quick, on quitclaim deeds, it's probably 50-50, maybe 60-40 now, as to whether or not, if you have a trust set up and you've done the legwork of getting your trust done, which I implore all of you tonight to do it, and I'm going to give you a great deal later, but it's me. I want you to get it done. The quitclaim deed, when you transfer it into your trust, does not have to be filed with the deed. With the register of deeds or wherever it is you are located. Because if you want to stay invisible, you don't want people. What happens when someone realizes you have a trust? They think you have money, right? I'm not suggesting. I don't know what all your assets are, but don't give them a reason to do that. So you get to keep it. We keep ours for our clients in their estate planning binder that they get, because it doesn't have to be filed until that person passes away. And in fact, transfer is effective upon signing. I'm sure many of you savvy real estate entrepreneurs know that. But I'm here to tell you legally, it does not have to be physically filed. So if you're hearing that out there in the world with other advisors that you may work with, just know you do not have to have it physically transferred. In fact, a case just came down dealing with the uncapping of taxes. I know we were talking a little bit about it in joint property owners. Now you can have a loved one on the deed and not have an issue with uncapping. It's taken years to get it to that point, but that's it's just something to know if there's a question out there with regards to if you have loved ones that have placed a child on there, and the assessor is coming to say, wait a minute, that's an uncapping. We want more money now from it. So just know that there's ways to fight it, and our Supreme Court just finally did something. Now, the actual trust part, I want to talk a little bit about some of the clauses in the trust. Now, what happens if you don't have property in the trust? You just paid the attorney a boatload of money or a little bit of money, and the trust doesn't work. So what happens? You go to probate court. To do what? To tell the court to put it in a trust that doesn't work, which may or may not work to begin with. So your intention of doing all this great stuff, bypassing probate, giving 80% of your real estate empire to your child that was working with you or your loved ones that were working with you, is now not going to go that way, because now you're in the probate court and the trust failed. And at the same time, under Michigan law, if you have a spouse, property usually goes to the spouse, and then down to children. If you're in second marriages, there's a distribution, there's a monetary amount. If you don't have a spouse and you don't have kids, money flows upwards to mom and dad. So if you have mom and dad who are in a nursing home and you don't have a spouse or children, it's important to have a trust, because mom and dad may not want to deal with your real estate stuff. Guess who does want to deal with it in the probate court? The attorneys do. That's probably who would want to be there. They would have to help mom and dad. Then they'd have to find and potentially even have a public administrator, because mom and dad may not even be competent to go into court to handle that. So there's a reason why if you aren't married and don't have kids, there's one reason why you should have your trust. And of course, if you have insurance also. But I wanted to touch quickly on what you see here on the Casanova clause. One of these, I had a client that unfortunately passed away from cancer. So we kind of knew it was, it's one of those where you know, unfortunately. And he had about 4 or 5 different properties across the state. Him and his wife had 3 kids apiece from a prior marriage. Yes, it was a Brady family. And the question was, and the kids ranged 14 to 22, somewhere around there. What's the intention? How do you dispose of and distribute the assets in a way to where some of these kids who are minors to begin with whether or not they may be able to get their hands on it. More importantly, how do you prevent the stepkids from suing the spouse who you want to take care of your spouse? I mean, usually that's what when clients come to me, they say, yeah, I want to take second marriages, third marriages, first marriages. I want to take care of my spouse when I pass away. How do you do that in a way to protect against that emotional turmoil that will happen when that individual passes away? Because in our case, we actually set up, and the Casanova Clause says, I'm afraid that when I leave you my property, you're going to go off and find who? Casanova. Guess what Casanova does? They go get married, and what are they doing? They're enjoying the property that, in this case, that the gentleman, because it was the man who passed away first, who worked hard to create, now is going off with the second wife to a Casanova, who potentially may have use of the rights, and now his kids are essentially, to a certain extent, disinherited, and they are SOL. This clause protects them from that. So if you have a concern, if you are in a second marriage, and many families, there are many families nowadays with second marriages, third marriages, with kids from prior marriages. This is one way to protect them, because if they're not in there is that potential. In this case, the kids, the evil stepkids, which I called them, because they ended up, the grandmother, who didn't like me very much, ended up they hired 3 attorneys, one of which you would know, I won't say the name, but he got the $8 million against the city of Detroit. In which, by the way, coincidentally, all the stuff you heard about, how he kept stuff from the court, yeah, he does that continually. He did that in this case. So that's kind of just led me to believe that's just what he does. So, but once we had the clauses in place, all the documents were in place, nothing was broken, all the intentions were still laid out, the spouse was still able to enjoy the properties. So by having these items set up, we prevented the contest, which is one reason why you want to have your documents set up, so nobody can protect. Everyone hears talk about Nevada Corporation, you hear about bulletproofing your assets. This is one way to do it, because that's what we did, and now they in turn aren't harassing. For 8 months, imagine the feeling, and you in turn may be gone, but your spouse, ask them, how would you like to for 8 months go through torture and turmoil by stepkids or business partners coming in that are threatening to sue and are suing with an attorney? Is that what your spouse wants to go through, or your loved ones? Probably not. So again, hopefully there's some impetus to get it done. Or if you've done it already and it's been years, I'm going to talk a little bit about the medical powers and the HIPAA releases and why you want to have those updated. So while you're doing that, guess what? Have your trust looked at, because there's 15 critical points. I can't get into all of them right now, but on the front of my blue form, which I don't have in front of me, email me at it's free estate planning tips@gmail.com. It's on the front of the blue thing, not on my card. If you email that, I'll put you on the list to get some of these tips and suggestions and things like that. I will email you my report that I created that illustrates the 15 critical points, so you can have them for your own viewing pleasure. But these are a few of them that I've gone through. Some of the funding, the protections, obviously the trust, the wills, and now the medical powers. The most important document, I think, outside of property is your health. How many of you want to know that if you become incapacitated, now your loved ones may not know what your intentions are? Everyone knows what happened with the Terri Schiavo case in Florida. 10 years of litigation, $200,000 of lawyer fees, and there still wasn't really a resolution. I think the story that came out was that he was the one that actually caused her to be in the coma. Now, I don't know that. None of us were there. But there's ways to prevent that here. And a lot of people have heard of the living will. The living will is part of your medical health care powers of attorney and your patient advocates. You nominate someone to have access to your, to direct who takes care of your mental health, guardianship reasons, if you want to stay in your home and get in-home health care. That is what your advocate does, because it's based on what your intentions are. Now, the 5th document is what we in turn call our HIPAA release, because you usually don't walk around with a 20-page document going, oh, by the way, here's my medical power of attorney,